Hello, everyone. My name is Gino Satriana, and I am the Executive Vice President of Rio Rancho School Employees Union, and I'm also your full-time representative. I am doing a slideshow of employee rights. You can call it a training, a slideshow, information, whatever you need. It'll be at your fingertips. So that's what we're going to talk a little bit about today. So let's get started. There's my information on the front page. I'll leave it up there for a couple seconds so that everybody can see it. Okay, what the outcome of this little slide is just basically do. I want you guys to realize that you'll have a better understanding of this of your rights and public school employees have under federal, state, and local laws and policies, along with our contract. So under federal, state, local laws and policies, and your union contract. Participants will be better prepared to defend your rights if need be. Just what is a right? Right is an abstract idea of which is due to the person or governmental body by law or tradition in nature. Okay. Legal rights, in contrast, are based upon society's custom and laws. I'm not going to read through all of this, but this is pretty much just a definition of what is a right. So a lot of people will come in and say, oh, you violated my rights. You violated my rights. Well, you got to make sure that you're using that correctly. If they violated your rights, what rights do you have? Make sure it's in the contract. Make sure it's in the law. Make sure it's in policy before people go around and start saying you violated my rights. So I just put a little definition of what a right is or what rights to have are. Okay. So I'm going to start off by doing the law first, and then we'll go into our contract. So understand that this is just going to come in sequence of what basically are how the sequence of what your employee rights and how they're covered. So I hope that makes sense for someone that is just like, well, what do I do here? This is going to tell you exactly what you can and can't do, or help you to figure out if that is. Now, you have myself and you have Billy, our president, who we can guide you through these because you have a union. And if you don't know what really a union does, go to our other tab where it says Union 101. Watch that one. You'll be able to understand it, and then watch this one, and it'll come a little bit more clearly through for you all. So rights under the federal law, you have the Fair Labor Standards Act, and then that's FLSA, okay? And then you have the EEOC, which is the Equal Employment Opportunity Commission, okay? Those are the rights under the federal law. That's federal. Okay. Fair Labor Standards Act establishes minimum wage, overtime. They hold, accountable to employee standards affecting employees in the private sector and in federal, state, and local governments. You all are local governments. So the Fair Labor Standards Act also is, helps out in this situation in the private and public sector. Basically, that bottom line there, federal, state, and local governments is a public sector. So it's private and public sector. That's for everybody. Covered non-exempt workers are entitled to a minimum wage of not less than $7.25 an hour. This is an old per hour effective January 24th. I've got to get the new standard, but this is just an example of what the Fair Labor Standards Act and the bars they're allowed to set. Overtime pay and at a not rate less than 1.5 times the regular rate of pay is required for 40 hours of work in a work week. Everybody's like, well, I get overtime because I worked not 10 hours in a day. Well, if that's in your union contract, yes, because then they have to abide by the union contract. If there is nothing written, then you have to follow the Fair Labor Standards Act, and that's time and a half after 40 hours in one work week. That means if there's a holiday in there, you didn't work, you only work 32 hours because you were off 8, you have to work 40. And then sometimes, again, I'll go through the bottom of it, what your rights are when you get the union contract. This is strictly Fair Labor Standards Act. And again, you guys can always contact us and I can walk you more through it. This just gives you a starting point and an idea. Minimum wage, again, January of 2020 was $9 an hour. It's since gone up to that. We have to address that. I haven't got the new slides, but you understand basically what the federal law covers in the sense of what the law covers. This is a big one, covered to non-exempt employees, teachers, counselors, Basically, certified staff who are salary do not fall under overtime. Okay, so overtime is for hourly and basically certified people that are on a fixed hourly regular work week is allowed the compensation of overtime by the law. This is, remember folks, this is law. Okay, hours worked are ordinarily included all the time in which an employee is required to be on the employer's premises on duty or at a prescribed workplace. Again, hours worked means worked hours. A lot of people I get phone calls on that say, well, I didn't get paid my overtime time and a half. And I was like, well, you guys had a holiday in there. And they're like, well, but I work 32 hours. Shouldn't I get overtime on that? Not unless it's in the contract, but according to the law. And people like to throw the law. Well, according to Fair Labor Standard Act, this is what I'm allowed to have. No, it's not. You got to read the contract because this could fall into it. And it's right there that you have to work 40 hours at the employee's premises in order to get your law above on the overtime. So hopefully that makes sense. Okay. On call time, again, this is what the law states. Okay. On call, I mean, we have a few of these. Employee is required to carry a pager. On call time is not hours worked when an employee is required to have a pager, or a cell phone. That just does. That's not hours worked. Employer is required to leave work at home, or there's a typo there, where an employer can be reached. Okay, just because you have to, you're by your phone or whatever the case is, you don't get paid for being by your phone. This is the law, folks. Remember, there's brackets of what I'm going to go through on this. This is federal law. Okay. Pay raises are generally a matter of an agreement between an employer and employee or employee's representative. Pay raises to the amounts of above federal minimum wage are not required by FLSA, Federal Labor Standard Act. Okay, you guys are protected by our contract because it's by your employees. See where it says or the employee's representative? We are your representative because you've got a union contract. We negotiate your raises. The law, the Fair Labor Standard Act, does not cover your raises. So know the difference. This is the law. Overtime pay, same thing. I just use of overtime, compensatory time, and in lieu time at 1.5 hours. Again, it's bargained by your representative. We have it in the contract. It doesn't necessarily mean that, and we can always refer back to this law to be able to, and it does in our contract, in the union contract that we have, the negotiated agreement, we refer to the Fair Labor Standard Act. So this is in law and also in our contract. So, but this is just an idea of what the law covers. If you didn't have a contract, you could only go by this. Ours is kind of a little bit better because we add some things in there and we have this. So you're double dutied on that. Okay. So, breaks and meal periods. This is a big one for people. Oh, I deserve 2 breaks. Not necessarily. Okay. The Fair Labor Standard Act does not require breaks. Does not require breaks or meal period to be given to workers. So the Fair Labor Standard Act does not do that. We bargain it, but they don't require the law. So people, this is a big one that people say, well, according to the Fair Labor Standard Act, I'm allowed this, 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 and this. Well, look at the Fair Labor Standard Act. Some states may have requirements for breaks and or meals. So we got to look to see what's in the state of New Mexico and also what it is. Here's a perfect. The benefits are a matter of agreement between the employer and the employee or the employer's representative, which would be our RSEU. We negotiated your breaks and your meal times. Everybody says, well, it's in the Fair Labor Standard Act. No, it's not. Okay. It has a little bit here. Meal periods are not hours worked when an employee is relieved of the duties for the purpose of eating a meal. If an employee is asked or suffered to work during a meal break, it becomes paid time. Again, that is negotiated with the contract. This is just what the law is stating that we can do. Rest periods short of duration, normally 5 to 20 minutes, are counted as hours worked and must, if allowed by the employer, be paid. Again, that's a key thing. If allowed by the employer, we negotiate that you get a duty-free paid non-paid duty-free lunch. If we bargain it and say we want it paid, then we would have to go to an 8.5 hour day, but everybody chooses to go to 7.5 hour with the 30-minute lunch. So those are areas that are allowed by it. So people that come back and say, well, the Fair Labor Standard Act says I'm allowed 2 breaks. No, the Fair Labor Standard Act doesn't say you have that. Okay. Other part of the law is EEOC. I'm going to go through this. This is another area of where I tell people that, hey, it's sexual discrimination. We have a contract, whatever the case is. Here's how you go about filing it. We can't file grievances on this in a sense. We can assist on it. This is in our negotiated agreement, but this is a different entity that it falls under, like hire, promotions, discharges, pay fringes, and certain things like that. So this is a separate entity that you can file a complaint and they will look into it and investigate it. This is the EOC. And again, we can walk you through that. Sex discrimination, this just breaks down. I'll leave it up here for right now so people can read it. This breaks it down into sex discrimination, retaliation, age discrimination. These are all under the law of EEOC. Okay. Okay, a lot of people call me up and says, this is a hostile work environment. What is a hostile work environment? A hostile work environment is one where the words and actions of a supervisor, management, or coworker negatively or severely impacts another employee's ability to complete their work. Any employee can be responsible for creating a hostile work environment. Okay, so there's your definition of a hostile work environment. Sometimes people call up and say, Gino, this is a hostile work environment because they have a supervisor or a principal that is just being really mean and rude and direct, and their tone is wrong. That doesn't necessarily constitute a hostile work environment. We have to look into that and investigate it, and also have documentation and facts to be able to prove that it's a work environment. Most of these things start off as toxic environments and morale booster, the lowering of morale, and that starts off as that to where it could lead to a hostile work environment. But a lot of people will call and immediately go to hostile work environment. Okay. Hostile work environment requires, here it is. You guys can read it on your own here. An employee with an unkind work create a hostile work environment. Okay. Unwelcome conduct or harassment is based on race, sex, pregnancy, religion, national origin, ability, age, and disability or genetics. Harassment is continued and long-lasting. Again, we have to investigate and look into it and have documentation. Hearsay is not documentation. He said, she said, she said, he said, she said, all that kind of stuff. We don't have any leverage to be able to prove, and nor does the district have any leverage to be able to say that it's that way unless it is brought to our attention and there is backup documentation in writing, video, audio, whatever the case is, to be able to prove that. Conduct is severe enough that the environment becomes intimidating, offensive, or abusive. It can't just be say, oh, I feel that this is what's going on. We need to have proof. We need to have documentation. It needs to be shown. Yes, you come to us and say you feel that way. We can start investigating, but it's going to be job of the employee to be able to give us information to where we can prove that it's a hostile work environment. Here's the other thing, to work performance is hindered. Again, if your work performance is hindered, this is areas where you could potentially have a hostile work environment. And I'll leave that up there for a few minutes. This may include severe, pervasive, and unwelcome behavior, words or actions. Okay, that have it. Now, we talk about words and actions. Words. Okay, sure, the words can be that way, but there's easy ways to follow up. And what I teach and I try to preach to everyone, and so does Billy and a lot of our exec team, will say, hey, follow it up with an email and say, per our conversation, this is what's said. To be able to have it documented, but words or actions that, if not amended, would make the employee unable to function in their role. So again, this has to have effect in your role. Putting you out in the hallway, okay, 4 days out of the 5 days to educate your class, or the EA has to sit out with a group of students out in the playground 4 days out of the 5 days a week. That becomes frustrating, which could it potentially lead to a hostile work environment. Why are we being segregated in this sense, and why don't we have the ability to be able to do that? That's just an example to where it would make you unable to function your role. Okay. All right. So that was the law, folks. Rights under the I'm sorry, that was the federal law. So again, to recap on that, you had the two. You had the EEOC, and then you had the Fair Labor Standard Act. That was all of those that are in there. And again, that last one I just went over was under the EEOC for a hostile work environment. So you can claim that, and they're going to ask you to investigate. And they're going to come in and interview to see if it truly is a hostile work environment. That's a lot. Now we go under the law. So the first one was federal. This is New Mexico law. Here's the Bargaining Act. That Bargaining Act is PIBA. If you go to our Union 101, you'll understand what PIBA is, and I touch a little bit on here, but PIBA is the Public Employees' Right to Bargain Act, which means we have a right to organize, and we have a right to continue to organize our union and grow our union for voices. The School Personnel Act, again, you go to that Union 101, it'll explain to you. The School Personnel Act, school board policy has one that actually has the right to bargain. So that's in there. And then again, we have the New Mexico Whistleblowers Protection Act as far as the state law. Okay. Negotiated agreement, union contract. Of course, Union 101 goes over this, but you guys have a contract. Okay. This is the contract that we negotiate with the district. The district basically and the union get together. We go over it. And we have a great relationship with the district, folks. So we collaborate to get what we need for the benefit of the staff, for the betterment of the students of public education, okay, which is Rio Rancho Public Schools. So we negotiate your terms and conditions. This is what your negotiated agreement is, and this is on our website. So this is what we negotiate. So this also, if you notice, all those two areas that I'm talking about, which is the federal law and the state law, New Mexico state law, we have the right underneath the state law, which is the Bargaining Act, to have this. This is what this union contract is. Okay. So with that being said, under the state law, we have a right to bargain. We have bargained. You have a working contract. You have a voice. Everybody is protected. We're a wall-to-wall union. Everybody is protected by the contract. What's the difference between a dues-paying member and a person that's protected by the contract? The dues-paying members gets a lot more of the benefits, attorneys, things like that. A lot of events. They get the right to vote on this contract. A regular person that's just protected by this contract doesn't get a right to have a say in this. The say in your union contract is your dues that you pay. You get to say what's in this contract, what you want in this contract. You get to vote on it. You get to ratify it. This is the union contract. Okay. So I'm going to go over one of the articles in this because this is an employee rights training. In that negotiated agreement, folks, is Article 9, disciplinary action and employee rights. Okay. It goes down the line from A to I. And this is exactly what we negotiated outside of what the law protects you on, federal or state law. So this is actually your working contract by state law you're allowed to have, which we added extra stuff in there so that you have rights. Okay. So this is this area here. And again, anytime any one of these are violated is a potential grievance. We'll talk about it. We'll start the grievance process, so on and so forth. If this doesn't fall in there, and remember when I said earlier in the slide that if there's not a violation of the contract, it's not grievable. We cannot grieve state law, but if a state law is in our contract, then we can grieve it. And if the language is in there, there's a difference between a gripe and a grievance. This is what I'm talking about. Article 9, disciplinary action, employee rights. These are your rights. Okay. Rio Rancho Public Schools Employee Standards of Conduct. Okay, let me go back up to this one. See that Article I, all employees will abide by the RRPS Employee Standards of Conduct. There it is. Okay, this is the first piece, and you all have this because the district gives this to you. Okay, at the very beginning that you're supposed to follow. Okay, so you all have this area. Okay, so that's employee standards of conduct. That was the letter I. Management also has their rights as far as in the union contract. So we need to understand that management, we also negotiate, because if we're going to negotiate employee rights, management is going to negotiate management rights in the contract. So these are the things that I'll always say. Remember, hey, people say, well, I got moved, I got transferred, I got this. Do they are allowed to do that? To a certain degree, we need to go in there, investigate, and look at to see what article this might affect. Establishing a revised work schedules of work. A4 in management rights, they have a right to establish and revise schedules of work. I'll give you an example. Our maintenance guys in the summertime change their hours to different hours. The management team sends RRSEU a letter saying, hey, we're going to give notice that we're going to change this because they want to go from 6 to 2:30 and they got a buy-in on it, or they have to do this. As long as they follow the union contract and offer what's in the union contract, and let me give you an example. As long as they offer the 8-hour workday in there and they want to go tens, and it's they get a choice in it, they can do that. They can't just say everybody's going to go tens, because that's not in the contract. The contract, they have to follow the contract first. If they want to add a benefit, they want to go 4 tens and Fridays off, or they want to go 4 tens and Mondays off, they can add that in there, and people can voluntarily say, I'd like that. But if they don't want to do that, they still have to give the opportunity for the employee to work an 8-hour day, because that's in the contract. Okay, so that goes to the assigning shifts and so on and so forth. So there's your management rights. All right, grievance. A grievance is an allegation and a violation of the negotiated agreement. You've heard me say that about 3 or 4 times now. A grievance is a violation of the negotiated agreement, and that's for all wall-to-wall people. So if there's a violation of the contract, we can grieve it. If there's no violation of the contract, we've got to look to see what happens. Now, if it's potential, we'll talk to the principal, we'll talk to administration, we'll talk about it and say, hey, listen, it's coming close to this. Can we look into it? Can we investigate it? Can we make sure it's not going to happen? And ultimately, we pretty much get it. Again, Billy and Dr. Cleveland have a great relationship. Myself and HR have a good relationship. The union and the district work together to where we don't get a lot of reprimands and they don't get a lot of grievances. So our people don't get reprimanded a lot and they don't get a lot of grievances. Now, that doesn't say that everybody's protected from a reprimand by any means. And it doesn't say that the district is protected from getting a grievance. What it says is that we collaboratively work together to try to stay away from that. Okay? It's kind of like going 57 and a 55. Are you breaking the law? Yes, because it says 55, but it's kind of touch and go depending on how the officer's day is going. So that's kind of how that is. So, let me talk about the grievance procedure is owned by the organization, not the individual. I want to make that clear. The union, it owns the grievance procedure, not the employee. It has to come through the union. Also, you can't go out there and write a petition and a letter to whatever the case, a petition on your own without letting the union know what you're doing, because the union is your representation. Now, if you go and start a petition and however you want to do as far as what's going on at your school and what's happening, and you come through the union and we go through the process, now we've started the grievance process. If you start and you have all these signatures, that's fine. If you could do that without the union and you do it on your own and people petition, the district's going to say, have you talked to your union? APS is going through that now, where the APS is telling a specific entity to say, hey, we support you, but you got to talk to your union first, because some people went to the board. So understand that we are your representative and we own the grievance procedure. Okay. Here's your flow chart. Basically, if you feel grievance occur, you need to contact Gino Satriana immediately. The reason why I put my name on there is because I am your full-time rep. A lot of times Billy's in class, or Missy, or Paul, or Melissa for SLPs, Paul for ITs, Will for related arts. They're in their classrooms. You call me, and you can call me during your duty day if you feel that an article is being violated. Now, you can't talk to me just for any old union stuff. We can't organize during the duty day. But if it's a potential violation or a hazard or a safety hazard, you can call me during your duty day. That is in our contract. We can't just organize during the duty day. That's why a lot of times you'll see Billy's emails come across and it'll say, please open outside your duty day, because that's information. But if it's a grievance procedure, if it's something on your terms and conditions of employment, you can call me immediately on that. Okay. So RICU will determine what the article in the contract and violated is. A lot of times, if I will tell the member, hey, take a look at this article, read it for me, see if this is violated. Take a look at this article. So I will start the representation part of it to tell you, hey, listen, read this over. Let's see it. Let's sit down. Then in the process of that, if there is a potential violation, we then go to the executive board. I will bring it to Billy. I will bring it to the executive board, those members that I just mentioned. They're the executive board team. I will bring this to him and say, hey, let's go over that. This is what this individual wants. You can also have the right to meet with all of us. And then we'll see if it's a grievance process, a procedure, and if it's actually a violation of the article. Because, folks, ultimately, we want to make sure that the principals at the sites, or your supervisors at the sites, whether it be facilities or whatnot, are also adhering to the contract as well. So it's not just the district, it's not just HR and those people. It's your immediate supervisors. If your immediate supervisors aren't following this, it can be brought to our attention, and then we'll take it higher than where they're at. Principals, elementary's principals are held by are supervised by Jana. The secondary principals are by Renee. I can take it to either one of those two and say, hey, listen, we've got a potential. Can we look into this? Or what's going on with this? Facilities has different supervisors in there. Custodials do different supervisors. EAs, different supervisors in that area. Special ed is Jerry Reeder. So there's areas that we can go touch that in there. Level 1 meeting, this is after the grievance procedure happens. So a lot of times we'll try to do a union management committee meeting. It's in the contract, UMC. Okay, it's under union management committee. We will talk about it. We will bring the groups that are possibly there's a potential violation and talk about it that way. If it doesn't work out that way, now we start the grievance procedure as level 1, 2, and 3. Okay, and then if we don't get what we need out of it, ultimately arbitration takes place. Now, this is also voted on, and again, this is also with areas of membership and non-membership and protected by the contract. But again, we want to make sure that the union contract is being followed by management. Okay. And also the union contract's got to be followed by employers too. So we got to make sure both sides are following this. And if the management team is not, that's where we jump all over it to make sure, and we go through the process. So that's your flow chart in that. Then in other areas where it's terms and conditions of employment, we had this about, I want to say about 12 years ago, we had to file the one that I remember. There's been a couple of them, but a prohibited practice complaint was security came to the union and said they are making us saying that we have to wear that we can't wear shorts, or that we have to wear these certain things, or whatever the case was. I can't remember distinctly about it. And they basically made it a law. Well, or they changed it. And they also had something about comp time. There was a couple different areas in there, and we didn't have to go through the grievance procedure because this was a violation. Okay. It's a procedure that is violated under the area of where it's the terms and conditions of employment. And the first type of prohibition involves an action on a part of an employee. An employer shall not discriminate against a public employee regard to the terms and conditions of employment because the employer's membership of the labor union. So they can't come after you because, you're a member of the labor union. And again, we're wall to wall. So that's pretty much everybody. Interfere or restrain for public employees, exercise of rights guaranteed underneath the bargaining act. So they cannot, underneath our bargaining, the bargaining act of PIBA, they can't restrain us from organizing and talking. That's a prohibited practice complaint. Discriminate in regards to hiring, tenure, term employments, things like that. Yes, do we get a lot of questions about this, or filed an affidavit, petition, a grievance, or complaint, or given testimony in a labor action, or because an employee is forming, joining, or coming to union? This is, again, this is kind of the union busting area. Prohibited practicing complaints can be filed in that. Now, as far as the hiring and that the management has a right to hire whoever they want. They don't have to come to the union. This is not what this is talking about. So understand that. Refuse to bargaining in good faith. So, I mean, that's when now we get to the bargaining team. So that's a prohibited practice complaint. Employee prohibited practice complaint is this right here. And I'll just leave this up so that you can do that. Just the areas where the district or the union can file employee prohibited practices. Okay, termination and discharge. We get a lot of these questions. I'm not going to spend a lot of time in this because this is kind of it read. Remember, your knowledge is power in this. All educational professionals should know their rights on the terms of discharging. Okay. Termination means, in this case, certified employees. That's the teachers, social workers, and everybody that's certified, SLPs, counselors. The act of not re-employing the employee for the following school year, or in a case of non-certified, the act of the employee's relationship in employees. The reason why I put this slide up here, folks, is because of this. If you are a short-term or a long-term employee and you came in before after the district started their school year, that is considered a short-term or a long-term, depending if you do it for the semester or if you do it for the full year. You will get a letter that says termination. Okay, that termination is not that you've been terminated from your job. That termination is termination of your contract. So people get really skittish on the fact of that termination. We are trying to talk to see if we can change that language at the top of the page, because we get it all the time. In May, I got a termination letter. Okay, it's a termination of your contract. You can still go to another district and they'll say, have you ever been terminated? No, you haven't. Now, termination of employment is different. That means you've done something wrong, you've been written up, things like that, and or discharge, like I put. So understand there's a difference. Now, there's a new law that has a probationary period, okay, for our PSRPs or our paraprofessionals, or EAs, custodians, all that. That's what I call the PSRPs. EAs, the non-certified employees. You're allowed one entire year. Before it was 4 years. Now it's one entire year. We bargained for that. Your unions went to bat and said, we need to make this a year probation. It doesn't need to be a 4 year. Now, educators, your certified employees, you guys are still not tenured until after you sign your third contract at the beginning of the year. Not complete. So know the difference of tenured. So a tenured employee that is a certified employee, teacher, counselor, so on and so forth, that are salary employees, you all DIAGs, SLPs, you all have a tenureship of up to, for the first year, non-tenured. Second year, non-tenured. Starting August of your third year and you sign that contract, you are now tenured. The difference between tenured and non-tenured is tenured employees have to go through due process and just cause. Non-tenured, they can give you one of these letters and tell you that we're not renewing your contract for any reason whatsoever. Okay, so understand that. Termination and discharge, I'll leave this up for a little bit longer. Discharge is a term that does not apply to classified employees. That's your paraprofessionals. Discharge applies to the certified teachers, counselors, social workers, DIAGs, SLPs, all of those certified employees. Discharge does not apply to classified, okay? And this just kind of gives you an idea of what your rights are. Okay, New Mexico Whistleblowers Act, Protection Act, the New Mexico is pretty cut and dry. I'll leave this up here. We don't use this very often, but as you know, if you watch Snowden, that in the federal case, because he saw something wrong in that show and he reported it, he was protected by the New Mexico Whistleblowers Act. Again, if you see something that is not right, and you report it, or that your principal's doing, and they can't come back and retaliate against you because you're protected by this act. There's a little bit more on it. Okay, this is another one that comes up in quite a lot of conversations. Free speech, not as free as it used to be. Okay, so remember, you are a representative of Rio Rancho Public Schools. I want to make that clear. When you are hired as an employee, they consider you a representative of Rio Rancho Public Schools. I've had a lot of issues with Facebook throughout the years where people want to post their freedom of, or they want to post what they want to post, and sometimes it involves public school stuff. Okay, so and you can't be derogatory. Let's just say you're at a specific school site. You can't be derogatory about that school site and think that you're not going to get into any sort of consequences or be questioned about it if that comes up. So you got to be careful, because freedom of speech, you're right. You have a right to do whatever you need to do. But they also have a right to investigate you, because especially if your name, your Facebook name says, I am a teacher at such and such site for Rio Rancho Public Schools. Well, now you've just told everybody what you do and where you work at and who you represent, and you got to be very careful of how you use your freedom of speech. Okay, so and again, I left that up there for long for you to be able to see this. There are some cases in here that will justify this. So make sure that we all understand that. I put that in there just to make sure that you are aware, because we have gotten a few of it. And then here's another one, another case that Citizens for the First Amendment Purposes Constitution. I'll leave that up there so that you can read it. Again, this is for your information. Rights determined at the local level, superintendent first. That's the rights that, again, like I told you before, in Union 101 in the contract, the superintendent has to sign off on our negotiated agreement. The school board has to sign off on it. So that's the collective bargaining, and our president signs off on it. The superintendent, the school board policies include grievances, transfers, and promotion policies. Okay, they have their own stuff that they do, but see that collective bargaining agreement. Ours supersedes school board policy if it's in the contract. As long as it's in the contract, they have to abide by the contract because they negotiated it and they signed off on it. Okay, but they can make their own board policies and stuff like that and run with their own board policies, because there's a lot of people that work for Rio Rancho Public Schools that aren't in the bargaining unit that still have to file the procedures. But like this grievance, transfer, and promotion policies, we already have that in that collective bargaining agreement. School board policy, okay, collective bargaining agreements right here, supersede pool board policy, not vice versa. Board policies may not be contrary to the law or state regulations, PIBA. So they can't contrary, and they don't. Rio Rancho Public Schools does a really good job of not contradicting or being contrary to the law. They follow the law. They follow those kind of things. They know that they have to follow PIBA, and so that's in there. And then here's the extra stuff in that interpretation of what the policies are, and so on and so forth. This one down here, it says, absent collective bargaining agreements, board policy may cover employment relations or any of these to be left to the administrative directors depending on the local school board. See that? Absent collective bargaining agreements. So that's anything that's not in the bargaining agreement. That's when they turn to school board policy. Whose salary can a school board set? Okay, we all know that they basically we negotiate your salaries. They can't set your salaries. It's negotiated. Who does the school board employee hire and evaluate? The school board only has one employee. They hire and fire superintendents. They only have one employee. The district hires and terminates or fires everybody else underneath that. So the district holds that. Now we have to negotiate on the process, but that's who does that. Who decides how much total funds are available for salaries? The state a lot of times takes that over. There is a budget every year that is reported in May. I think it's May 30th that it's due by. And also the state is funded because the tax dollars are paid for by public education. So that's salaries are kind of left sometimes. We can negotiate percentages. We did that before with about 4 years ago for the 36,000 for level ones, and we got a bump to 40. We're going to try to get the $15 an hour for paraprofessionals for a starting livable wage, so we can go to the state level and start to lobby for that so that the state can hand it down to the district, and then the district has to follow what the state says. Now, we always can go over and above, in which the district and the union have worked together on, to where we can go above and beyond what we can get and how much money. We did it for the bus drivers. We did it for the custodians. We're working on the EAs and the bus attendants right now. So we can go above and beyond. But technically, if the districts in the state of New Mexico wanted to say, this is what the district is, this is what the state is giving you, they can. We can negotiate pending on what the budget looks like for Rio Rancho Public Schools. Who fixes the salaries, employees, terminates, and discharge? I went over that. School boards. Here's a lot of the what the school board, local school boards' powers and duties are. I put that in there so that you all would have an idea of what their powers are. School board versus superintendents. I talked a little bit about this. According to the various school reform statutes, including House Bill 212, superintendents rather than boards employ fixed salaries. See that, and that's what I just went over now. Elections have consequences, folks. We all know that in what we've done. We're not going to say to vote on one side of the aisle or the other side of the aisle. We represent you employees. Employees have different opinions. Unions have different opinions. We represent you all and the constituents. But remember, legislators pass the law and stop bad legislation. Governors propose and sign or veto. You know, this is a trying time right now, to where we have gotten a lot of good bills passed with this current administration. And we've gotten a lot of public education money, and we're going to get a lot more public education money. But again, understand that you've got to really look into it. Don't just look at the party, look at to see what really backs what the public education area is and what we can do for public education. Here's your trio of rights from the court's decisions: Garrity rights, Weingarten rights, Loudermill rights. We use the Weingarten rights a lot when we talk about things, and I'll go over that. Garrity rights is pretty much, I'll leave that up there for a couple seconds. This is it's a little bit different than the Mirandum rights, okay? It's similar to it, but it's a little bit different. Weingarten rights, this is the one. If you're ever called into, this is on the back of my business card, folks, and it's on the back of Billy's and all of our executive officers' business cards. If you are ever called into an interview meeting with your supervisor or manager so they can investigate a situation which might result in disciplinary action, you have specific representational rights. These rights are summarized below. Leave those in there. So again, now, remember, the district can come in, or a principal can come in and say, I want to have a conversation with you. And that principal can say, it's just a conversation. You ask at that point in time, is this disciplinary in nature? If they say no, you can have that conversation, okay? Get that no in writing, because you want to make sure and you can do that after the fact. You can send an email and you can say, per our conversation, when I asked you before the meeting started, if this was disciplinary in action, you said no. Now, again, if you're in that meeting and at any time, if you feel that it's punitive or you're being scolded, you can stop that meeting and say, I don't feel comfortable at this point in time. Could I please call my representative to be in this meeting because I feel like this could lead to disciplinary action. Okay. So understand that that is your Weingarten rights. So again, any meeting that's called and you feel, and you can say it, you've got to know it. Now, they don't have to offer it to you. You have to ask for it. The only time they have to offer you representation to you is when it is disciplinary action. So that's when they have to. That's when they have to offer it to you. Other than that, they don't have to offer it to you. You ask for it. Okay. This is just kind of a little when the Weingarten rights was incorporated. Since much of the New Mexico Public Employee Collective Bargaining Act is based on the precedent, we also have similar rights under the New Mexico PIBA. So that's in there. So you hear this? If the discussion could lead in any way to my being disciplined or terminated, I respectfully request that my representative be present at the meeting. Without representation present, I choose not to respond to any questions or statements. You are allowed to say that. What situations do not give rise for Weingarten rights? This is very important here. Where the meeting or discussion is merely for the purpose of conveying work instructions, training, or needed corrections, like your evaluation process. If they're saying that you need they're trying to correct things, those type of things, again, that doesn't have the right to that. So that's why I say when you go in there, you say, is this disciplinary in nature? If you go in there and they say, no, it's a conversation and they're talking about work instructions, they're allowed to do that. Okay, they're allowed to give you directions. They're allowed to say, here's what they're, or training, where the purpose of the meeting is simply to inform the employee about a disciplinary decision that has already been made and no information is sought from the employee. Okay. We like to make sure the district will, if there is a disciplinary that has been decided, they will still give you a representative. They will still take care of that. So where the employee has clearly and overtly assured the employer prior to the interview that no discipline or adherence clauses will result from the interview. Okay. Again, that's what I was telling you. If they say no, it's non-discipline, you make sure that you follow that up with an email saying, when I asked you, you said it. So I'm just making sure that because the interview or the questioning or the conversation or the meeting, you said that this was not going to be a disciplinary action. Where any discussion that occurs after the employee has notified the employee of the discipline has been initiated by the employer rather than the employer. Okay. Loudermill rights. Again, this is a difference. It's involuntary termination that has that's when our attorneys get involved. But I threw that up there just strictly because of that doesn't have anything. We represent it, but the attorneys. This is for the attorneys that will use this. The employee has a right to speak or not to speak in the Loudermill. Folks, if you have any questions, oops. Oh, let me go back. Did I lose it? That concludes it. If you guys have any more questions, you can always contact me at my information's right there. You can also contact Billy. She teaches during the day, and so does most of our exec team. You can contact us at rrseu4933@gmail.com, and we will be more than happy to help you if you have any questions, any representation questions, or any legal questions. Please do that. Again, I want to make sure that you all know that we are not attorneys. We do have our attorneys available to the specific individuals that would get the representation of attorneys. Our attorneys do protect our contract. We are a dual local, so we get both NEA and AFT counsel to be able to help us and representation from our parent organizations. So with that being said, thank you very much for your time, and hopefully this was a useful training for you.